Hey everybody, it's Joel Williams and Chase Elleby with Williams Elleby here with week number 38 of our video series of 52 weeks of personal injury. This one's going to be fun for me because I'm going to present Chase with 5 different scenarios that could pop up, or maybe they have popped up before in a personal injury case, and ask him what he would do in that situation.
I feel like I'm in the hot seat.
You are.
All right, good.
You ready for this?
Yeah, let's go for it.
All right. Got my trusty notes right here. Scenario number 1.
Okay.
You receive a call
Yep.
from someone who has fallen at a business.
Okay.
You speak to someone with the company and find out that there is video cameras in the store. What do you do?
The first thing I do is I send a spoliation letter.
What is that?
So a spoliation letter, we talked about a little bit, I think, in week 37 or 36. But basically, spoliation letter is a letter sent to the company saying, hey, I'm Chase, I'm the lawyer, I represent Joel. They have fallen on your property, we're asserting a claim. If you have any evidence at all whatsoever, including video, incident report, you need to hold on to it. I send it to the store, I find whoever the registered agent is, send it to that registered agent. At a minimum, and then if I find other people that I think might just be affiliated with that store, I just send them off. You know, you can never send too many letters, so that is the first thing that I do, and the first thing that should be done in every sort of slip and fall case where there could potentially be video camera.
So why is it important that you do that?
So if I send that letter and the store, say, ignores it, and the video gets recorded over 2 weeks later, well, I won't necessarily know about that if and until I have to file a lawsuit. And then when I file a lawsuit and send the discovery, go check out our other video, and ask for that, if they say they don't have it, then I'm going to say, well, why don't you have it? I sent this letter, you should have kept it, or you should have held on to it. And that could potentially open up the defendant or the store to sanctions. And that could be like striking their answer, which basically means liability is admitted. So it really sets them up for sanctions.
Yeah. So that kind of leads to the second part of my question. So let's assume you send the spoliation letter.
Right.
Let's assume that everything is quiet. Nobody returns your call. Nobody responds to the letter. You have to file the lawsuit. Mm-hmm. You send your discovery out. You say, give me the video. Mm-hmm. And they say, we don't have any video.
Yep.
Then you mentioned sanctions, but like, how do you get from them saying we don't have video to sanctions?
So you depose a 30B6 rep or someone with the company, someone who maybe handles their IT, handles their security, whatever it might be, and find out what their policy procedure, what sort of cameras they have, whether or not they get recorded over. So find out kind of what happens with the cameras, like just generally speaking, okay? Confirm that you had the proper address, that you sent it, that they received it, to go ahead and set them up, getting sworn testimony saying, yeah, we had it, or we knew, or this is the right address, yeah, it was sent. Also sworn testimony that there may have been video or there should have been video. Because a lot of times, I shouldn't say a lot of times, but what will happen is they'll just stick their head in the sand, right? They'll just ignore it, hope that it goes away, and then it gets erased or deleted over. And then when that happens, that's why you have to send the letter, because we may never know. Like sometimes, there's been situations where we've sent the letter and the video's been completely just gone and disappeared. But a lot of times it's preserved. But without that letter, if they delete over it, because that's what they normally do every 2 weeks or however long the video gets deleted, then you can't really hit them for sanctions, because then they have a better argument that they didn't really know or anticipate that a claim is going to be made.
I gotcha. So you get that testimony and then you file a motion?
Yeah, right, sorry. Yeah, get the testimony and you file a motion with the court and say, court, they have spoliated evidence, meaning they've spoiled or gotten rid of or destroyed evidence. Here's what I think the sanctions ought to be. The other side responds and just says, they'll say something along the lines of, no, we didn't. I can't believe they'd make such false accusations. Mm-hmm. We really want to pay this injured person a lot of money. No, they don't say that at all. And then the judge decides, what the sanctions are going to be. And they could be anything from, I'm not going to sanction them, to completely striking the answer, issue preclusion, you're just having a hearing on damages. Yeah. It can kind of run the gamut, whatever. It depends on how severe the spoliation was, and kind of up to the judge, really, what they want to do.
Gotcha. Mm-hmm. All right, same scenario. You send the letter.
Yep.
Adjuster calls you up and says, "Oh yeah, come on, Chase, come on down to my office. I'm gonna show you the video."
Yeah.
What do you do?
Yeah, I've done that. I've actually gone and watched the video. So with slip and falls, it's funny, or I guess any premises type case, because the company, whoever has the video, they're not required to give us anything pre-suit, right? So I can beg and plead and ask for the video, and most of the time they're not going to give it to me. Sometimes they will. I've had adjusters call me and say, "Hey, I'm going to get you in touch with an attorney. This is all pre-suit. They'll allow you to go watch the video, and you can go to the office." And I'll go and I'll watch the video. It's been my experience when they do let you go watch the video, it's usually better for the defense. And so it's me watching the video saying, "Yep, okay, great, I appreciate it. We don't have a case." Let my client know, "Hey, unfortunately, I saw the video. The law's not in our favor. I'm not going to take you down a road where it's going to be a dead end, so I can't represent you." So it's a good and a bad thing. It's good in the sense that it kind of streamlines the litigation. It's bad in the sense that usually if they're showing you the video, they have a pretty strong defense. And then the flip of that's also true. If the adjuster tells me they have a video but they don't want to show it to me, then I'm like, okay, great, I'm going to file the lawsuit because I'm going to see it anyway, and the video is probably going to be favorable, and it almost always is.
Gotcha. All right, scenario number 2.
That was all just one question?
Just one question.
Jeez, we're going to be here a long time.
Final exam.
Right.
Scenario number 2.
I tell them to call Joel.
Yeah, you get a call. You get a call Monday morning.
Right.
Guy was on a bus in a wreck over the weekend.
Yep.
7 other people hurt on the bus. The other 7 people called billboard lawyers and hired lawyers right out of the gate.
Right.
Already hired them Sunday morning.
Right.
This guy wants you. You get a call Monday morning. Everybody else is hurt.
Right.
What's the first thing you do?
Yeah, it's a race. I send letters of rep out as soon as I can, because typically in Georgia, policies are written in a way where, like, if you look at your deck page, it'll say something like $25,000 for per person, $50,000 per incident, $25,000 for property damage. So if I know that there is a wreck where there's one at-fault party and there's multiple injured people, it really is a race, right? So I send a letter of rep out as soon as I can. I'm trying to get hospital bills, ER bills, whatever it is, to support my client's claim as soon as I can and send the demand out. Because insurance companies, when they're faced with multiple claims, they don't always have to wait for everyone to be done treating and to receive all the bills and records and kind of analyze everything separately. If I send a solid, strong demand for usually a minimum limits type case, and I send it quickly, and I cite the proper case law, which basically tells insurance companies you don't have to consider other potential claims, it's your duty to protect your insured for this claim and this claim only, then I try to get that policy out of the way, so then I can look to any uninsured motorist coverage. So,
all right.
Gotta be fast.
Let's assume it's not minimum limits.
Right.
Assume there's $100 million of insurance. How does that change your analysis?
Well, then I've got time. So I tell my client, just treat, there's no rush, there's nothing that needs to be done right away other than putting the insurance company on notice, putting their own insurance company on notice, doing our standard investigation, whether it's open records request, getting, photos, all that type of stuff. So it's not a race anymore at that point.
Gotcha. All right.
Are we on to 3?
Number 3.
All right.
All right. This time, you get a phone call.
A lot of phone calls. Good grief.
Instead of a person wanting you to represent them,
Yep.
this is an attorney
Okay.
that wants to refer you a case.
Okay.
You don't know this attorney personally,
Okay.
but that attorney's law firm has a reputation of getting cases through less than ethical means. I.e., people believe they are maybe ambulance chasing
Okay.
or running cases down. This case that the attorney wants you to assist with is a paralysis case
Okay.
against Walmart. There's tons of money.
Walmart.
Tons of money and bad damages.
Yeah, but Walmart's a pain to deal. Sorry.
All right, Coca-Cola.
Oh, okay, good.
All right. Good old Georgia company.
Right.
So it's against a big corporate defendant, bad damages, seems to be clear liability. What are you going to do? with the knowledge of the reputation of that lawyer's firm?
I wouldn't hold it against the client. Because the client's not really going to know. You know, it's kind of one of those, I would call it like an inside baseball type situation. Other lawyers watching this video will know what I'm talking about, but a lot of people don't know the problem with runners getting calls. I mean, you and I both have been in meetings with clients who have found us online, come, sit down, talk with us, and all of a sudden their phone rings and it's somebody they don't even know, have no clue how they got their number, trying to get them to go to this doctor, go see this person, we got you, you know, we can get you this lawyer. It's crazy. I have no idea how they even do that. But I wouldn't hold it against the client. And actually, honestly, kind of, it would probably, I'd be thankful that that lawyer who didn't know what they were doing or probably couldn't handle a case like that would at least have their client's interest to call us who could handle a case like that. So I wouldn't hold it against the client for sure, because you know they're still in a bad spot. They're still badly injured, and they need good representation. So
once you are in touch with the client, is there anything you would do to find out how they found the referring attorney?
yeah, I'd want to know for sure. I'd find out how they got hooked up with them.
Okay.
And what was going on, because that, like I said, it's I don't want to call it, I mean, not a crisis because it's not that extreme, but it happens way more than it ought to.
Let's assume that the client says, this attorney shows up in my hotel room or in my hospital room. No, I didn't call him. Nobody that I know called him and told him that I was going to be here. He just showed up and offered me $10,000 to sign this contract. What do you do?
I mean, I would call that lawyer and tell him that he's got a big problem on his hands. And I think I'd be obligated to report it to the bar, honestly. You know, so I would have to do that. I have to report it to the bar and tell them, like, this is what's going on. So.
Cool. Only reason I asked that with a different set of facts is that actually happened to me one time.
I said that story sounded familiar.
Yeah. So I just wanted to see what you would do. All right. No phone call this time.
All right.
Question number 4. You're at trial. The defendant calls a witness to the stand that you have never heard of, that they have never disclosed, that is seemingly out of the blue. What do you do?
Well, I object to the witness. I'll probably have a conference with the judge, ask the jury to be excused, pull up the consolidated pretrial order to find out if this witness was listed at all by the defense, find out what the purpose of the witness is being called for, because of course if it's an impeachment, type witness and things like that, they don't have to be necessarily identified. And then hope that it's not an impeachment witness, and hope that they fail to list them on the consolidated pretrial order and ask that the witness not be allowed to testify.
Okay. Same scenario.
Okay.
You approach the judge. The judge says, well, Mr. Elleby, your only option is I can pause this trial and you can go depose this witness, and we'll start back tomorrow. To go depose him at 7 o'clock tonight, and we'll start back tomorrow. Here's a court reporter, you can use mine. Or we're going to declare a mistrial, and you'll get on the next trial calendar, which might be 8 months from now.
I'm not doing that. I'm deposing him for sure. I'm not going to waste any more time. We're already at trial. Depose the guy or gal. Hopefully I can tear him up in the deposition to where they don't even want to testify the next day. And we can get to closing arguments and have the jury award us millions of dollars.
Gotcha. Now let's rewind to the Friday before trial starts.
Okay.
Similar scenario. The defense drops a astrophysicist expert on you in your case. Friday afternoon, 5:30 p.m. for a trial that starts on Monday.
Yeah.
What do you do?
I'd have to file an emergency motion with the court, ask for a continuance to give me an opportunity to depose that witness, and then if it's an expert, try to find a rebuttal witness and, really kind of blow up the defense and have the judge be real pissed at the defendant for dropping an expert on me after hours on the Friday before trial. So, and the judge will grant a motion like that, but it'd make me mad because everything would get continued. So.
All right.
Are we done?
Almost. Number 5.
All right.
I like watching you squirm.
Nah, I'm not squirming. These are softballs.
Softballs. All right. You have a client,
Okay.
neck injury after a car wreck. The client tells you, never had treatment to my neck before. Never had neck pain before. Here's the people I treated with after the wreck. You order the medical records, and the medical records talk about how this client has been going to a chiropractor for 27 years and being adjusted in their neck for neck pain during the course of that time.
Yeah.
The last adjustment was 3 days before client tells you, I've never had neck pain before.
Yeah.
What do you do?
Yeah, Houston, we have a problem. I get all those records, I call the client in, and have a heart-to-heart. I mean, because if I can't trust the client to tell me that they had this neck issue going on for 15, 20 years, then there's really no trust. That relationship is pretty much broken at that point. And for me to be effective, for us to be effective, everyone has to be honest with each other, the good, the bad, the ugly. And so in that situation, I'd tell them, hey, listen, I can't help you. And it'd be mostly because of the fact that they just, either conveniently forgot, which is what I'll probably go with, giving them the benefit of the doubt. And also too, at that point, they wouldn't even have a case. So.
Yep. All right, now let's fast forward a little bit.
Yeah.
And you order said client's medical records.
Right.
And there's nothing in those medical records about any prior neck treatment. So you think you're good. Client's honest and this, that, and the other. Comes time for your client's deposition, and defense attorney pulls out records from a prior treating physician where they had treated your client for neck pain. What do you do?
Is it just one visit?
Okay, let's say it was 10 years before. It was 5 visits of chiropractic care, and that was it.
So what do I do in general, like with the client or with the case? Or
Like, how do you respond?
yeah, you just kind of got to roll with it at that point. I mean, it makes sense. I mean, it's not completely outside the realm of people to forget if they went to the chiropractor a handful of times 10 years ago. And especially if it can be explained why it might have been missed on the front end, then that makes more sense than being at the chiropractor treating 2 days before the wreck, for the past 10 years and having a neck injury. So yeah, I mean, that happens a lot, honestly. I mean, a lot of clients will have some sort of neck pain or back pain that happened way, in the past from whenever the wreck was, and you just kind of have to deal with it and roll with it.
Yeah. Now let's change it up a little bit and say...
Just like 5A, we did 5A, 5B, 5...
Yep. Let's say it's not just 5 visits of chiro 10 years ago.
Mm-hmm.
It was 2 years ago, and it was a cervical fusion surgery.
Yeah, it's a little different, right? Cervical fusion is a little different. That's going to make the case that much more challenging. And of course, I'll be questioning the client, wondering why that was conveniently forgot, because most people aren't going to forget about a cervical fusion in their neck, especially if it was only 2 years ago, not even 30 years ago. I think they would remember that as well. So yeah, that'd be a problem.
Yeah. Would you stay with the client?
Would I stay for the client? Yeah, I would 100% stay for the client. But I tell the client, listen, we're in a real pickle. We got to get this case resolved.
Yeah.
So
Your case just got devalued by
Right.
about 95%.
Exactly.
Yep.
Exactly. So.
Okay. Well, I think you're still breathing.
Hey, you're on the hot seat next week.
You
so,
survived.
Yeah.
Right?
We'll see if you survive next
I'm gonna knock it out of the park. I don't know about you. All right. Well, that wraps it up for week number 38. Right. Week number 38 of our video series, 52 Weeks of Personal Injury. If Chase's scenarios have been helpful to you, we appreciate you giving us a thumbs up or subscribing to our channel. Hit that subscribe button, and you might see me fall flat on my face next week in week number 39.